Doctor, we got a video, and I reviewed the video. Does anyone there know when that video was taken? Because he obviously looks a whole lot worse than he did in that video. In the video, he was sitting up. He could move his head. He could move his arms. He could move his legs. How long ago was that video shot?
The video was March. I'm going through my videos now.
Okay, for several months ago, 2-3 months ago.
March 18th.
March 18th. And so he's deteriorated significantly since then.
I can't say that. I wasn't here then. I don't know what his condition was, and I never saw the video myself.
Well, I guess you could tell us.
At this particular point,
fairly
he is
significant.
total care.
I am glad that Mr. Mirabella has taken the time to dive in and see if he is trying to pull a quick one over the board with his illness. And the reason is that he has been found guilty over decades of doing the worst of the worst and it's somehow he has continuously gotten away with it. So let's jump into this. And at the end, I have some surprising information to share with you. Let's go.
Mr. Stoney LAPOINTE. Mr. LAPOINTE, would you please introduce yourself and give us your DOC number?
He can't really do that. He's got a trach, and
Okay.
he has difficulty verbally communicating.
Okay. Well, I'll go ahead and read some information into the record. This is set for today. Mr. Excuse me. This is the matter of Stoney LAPOINTE, DOC number 243841. Mr. LaPointe's date of birth is April the 25th of 1963. He's classified as a fourth felony offender. He is not eligible for parole. He has a full term date of 4/12/2024. He's currently serving a 12-year sentence on the charge of 2 counts of indecent behavior with a juvenile. We have information in the record that indicates Mr. LaPointe's convictions of 2015. He was found guilty by a jury in Acadia Parish. He was sentenced to 12.5 years on September the 3rd of 2015. The allegations are and the convictions are for having sex with his stepdaughter since she was 5 years old. Allegedly began in 2005. He was originally arrested for aggravated rape and oral sexual battery. Also in Evangeline Parish with the same victim, he was arrested for sexual battery and aggravated incest. He pled guilty to indecent behavior and received a 7-year sentence. He has prior offenses. In 1982, he was convicted of contributing to the delinquency of a juvenile. He had sex with a 14-year-old. 1988, he pled guilty to attempted manslaughter and was given a 5-year supervised probation sentence. In 1995, he was accused of having sex with 6 different juveniles. He was charged with 6 counts of sexual battery on a juvenile and intimidating witnesses. He was given 8 years and 5 years. This involved 6 different juveniles. In 1988, he pled guilty to the attempted manslaughter, which was reduced from attempted murder. He shot a man while the man was sitting in his car. I have reviewed the medical records. I've reviewed a video with Dr. Jonathan Roundtree, where he has indicated that Mr. LaPointe has induced squamous cell carcinoma. He described the conditions and he indicated that he will require nursing assistance for the remainder of his life. Mr. LaPointe is 59 years old. He has 2 recent disciplinary write-ups, one in January of 2020 for contraband. He had tobacco. And on April 14th of 2020, he was charged with defiance for allegedly making obscene comments. I don't show that he's taken any classes at all. I don't see that he's taken any sex offender classes. His records suggest he's not taken any anger management. He hasn't had any substance abuse treatment. I did review the video. Again, I would like more information on his current medical situation and potentially what might ultimately happen. So, Warden, can you tell me if he's had any classes? How long has he been in prison this time? And what classes, if any, has he taken? I show no classes whatsoever in his record.
This last time he came through Hunt Reception in 2015, and he transferred to Allen. It looks like he went back to OAS maybe for a year, and then came back into Hunt for from the jail for medical reasons. And he's been at Hunt since August of 2020.
Do you show any classes that he'd taken prior to his getting sick?
Let me see, completed GED. I'm not seeing any.
Thank you. Doctor, can you comment, please give us some information on Mr. LaPointe? I've read most of the records, the medical records, but could you, for the record, please elaborate on what his condition is?
Well, I will apologize. I've only been here 2 weeks, so I haven't had a full chance to review all of his medical records, but I did have a chance to examine him last week. And essentially, he started out with a tonsillar laryngeal type cancer. It extremely advanced. It said he has bony metastasis. Since that time, he's been trached. He's got a PEG tube for continuous feeding. He's basically total care. He has to be bathed, fed, clothed, everything. Like I said before, he can speak somewhat if he gets a good breath of air and holds his trach, but it's very difficult for him to speak, and it's very difficult to understand what he's saying. He also, I had to put him on an air pressure mattress. He's developed some very significant pressure decubitus, particularly on his right hip. I had to debride a fairly large amount of necrotic tissue last week. And
I'm not sure what that is. Explain to me what that means on his hip.
well, when you develop pressure sores is when a patient is immobile, and if they not able to turn or move themselves, and it's stage 3. Pressure sores range, they're rated from 1 to 4. 1 is like almost like an abrasion with a superficial skin. Stage 3 is like it's going all the way through to the deep tissue, to the muscle. And stage 4 is when there's going to be bony involvement. And it's almost to his hip now, but we're trying to aggressively treat it. Also, too, he's got a do not resuscitate on him. I have not been able to locate a LaPointe, but from what I saw in his previous records, apparently he had signed a DNR at the hospital when he was discharged and came back to Elaine Hunt. That was continued. I was able to have the discussion with him about advanced directives, and he did confirm to me that he wants to do not resuscitate, but I could not at this point ascertain any other advanced directives for him. He's on a slew of medications to treat various problems, and a lot of pain medications as well.
Doctor, we got a video, and I reviewed the video. Does anyone there know when that video was taken? Because he obviously looks a whole lot worse than he did in that video. In the video, he was sitting up, he could move his head, he could move his arms, he could move his legs. How long ago was that video shot?
The video was March. I'm going through my videos now.
Okay, for several months ago, 2-3 months ago,
March 18th.
March 18th. And so he's deteriorated significantly since then.
I can't say that. I wasn't here then. I don't know what his condition was, and I never saw the video myself.
Well, I
just know
guess you
that
could tell us.
at this
he's
particular point,
deteriorated fairly
he is
significant.
total care.
And his prognosis is dire. I mean, you anticipate him getting better?
Without actually seeing what the oncologist wrote, I would say yes. I would say that his prognosis is extremely poor, and long-term survival is at a very low percentage.
I do want to say for the record, Warden, when I review the records, it looks like he refused programs. That's what's documented. For the sex offender programs, he refused. That's what I saw in the case documentation.
Okay.
I don't know if you see
Oh, I did
that.
say yes. He did refuse.
Yes, ma'am.
Yes.
Thank you. And I don't know if you said that we do have law enforcement opposition.
Do we have any dates on his refusal? I guess I'm trying to figure out when he got real sick and whether or not he had an opportunity to take some courses before he got sick.
I can get that information. I would say, I mean, he bounced back and forth through the parish. I do show hospitalizations in 97. I'm not sure what that was for. But to say he was stable at Hunt would be from 16. Well, not really that. I see a geographical transfer back to Allen. So I don't find a long stay at either institution or parish through here for him. So I'm not sure.
Mhm.
When I was having some difficulty, Doctor, you said you did not review the video.
No, sir. Like I said, I've only been here 2 weeks, and the other doctor,
Dr. Roundtree was discussing on the video, and it sort of cut off. His voice cut off. And what he said when he was on the video, he was talking about the latest report from the oncologist. Bring us up to speed on that. And you may have already said that, but what was the latest report from his oncologist?
I can't comment on that. I haven't read over that. Like I said, I only got here 2 weeks ago, and the Dr. Roundtree left rather abruptly, and the other doctor quit the week before, and then a nurse practitioner quit. So I haven't been able to get to every case and get fully informed on all of them. And I would hate to give you a recommendation or a comment without actually having the document and being able to fully digest it myself.
Any other questions? Is Warden, any other comments you wish to make?
No, sir. I know that I can remember Mr. Stoney's video because I was doing the medical releases back then. And I think he was, I don't think he was sitting on side the bed. He was just able to move.
He was in the bed. He was in the bed. He was able to move his head back and forth and his arms up. My comment was he looked a lot different than he looks now.
And I can vouch for that, definitely. I know Dr. Prejean, is just getting to the institution, but yes, he has declined severely since at least our video.
All right. I'm concerned, obviously, about his history, the charges themselves, the fact that he hasn't taken any classes. There may be some mitigation as to why he didn't take the classes. He certainly is extremely ill. There's no question of that. My questions about what Dr. Roundtree said is because in the reports it suggested at some point he might get better. And Dr. Roundtree was addressing the new oncology report. So I'm a little concerned about that. So my vote today would be to grant his medical parole, but to add, if he recovers sufficiently, to return to prison to finish his sentence. Now, it's my understanding there is a place that you have for Warden. Do y'all have a place specifically that he will be going to?
We do have an option of a couple of nursing homes that will accept sex offenders.
My vote would be to grant, conditioned upon his recovery sufficient to return to prison to finish his sentence, to one of the approved nursing home facilities.
I concur with the recommendation of the medical director and secretary of the block. In this case, I concur that we moved to a medical facility that's going to be able to address his needs. And also that if his condition improves, he will be returned to prison. And that grant is conditional. Thank you.
I concur with my colleagues with the same condition.
His medical has been granted with the conditions as outlined by the panel. Thank you very much.
Thank you.
Thank you.
The time is 8:53. We will adjourn. Warden, thank you very much for your assistance. Doctor, thank you as well.
You're welcome. Thank you.
Unbelievable. Unbelievable. What's unbelievable about this is to listen to how many crimes he had, how violent, attempted homicide, a juvenile dating back, and he keeps being released out into prison, right? And then finally his last charge was by a jury, and they only gave him 12 years, and that just makes me sick. Now, what I really do respect about this hearing was Mr. Mirabella being thorough and wanting to make sure that this guy wasn't trying to pull a quick one over him. I respect that a lot. I have information to share with you. If you were wondering, was he trying to pull a quick one? In a nutshell, and thank you, Richard, for pointing this out. He passed away. He passed away. He died. I want to call it passed away. He died. He disintegrated off of this earth. Really, just less than a month after he got out. So he was not faking it. So the world does not need to worry about this monster. But let's just listen. And we have the court records, but let's listen to how many crimes it was that this monster perpetrated amongst the world. I put it at 1.5.
Convictions of 2015. He was found guilty by a jury in Acadia Parish. He was sentenced to 12.5 years on September the 3rd of 2015. The allegations are, the convictions are for having sex with his stepdaughter since she was 5 years old. Allegedly began in 2005. He was originally arrested for aggravated rape and oral sexual battery. Also in Evangeline Parish with the same victim, he was arrested for sexual battery and aggravated incest. He pled guilty to indecent behavior and received a 7-year sentence. He has prior offenses. In 1982, he was convicted of contributing to the delinquency of a juvenile. He had sex with a 14-year-old. 1988, he pled guilty to attempted manslaughter and was given a 5-year supervised probation sentence. In 1995, he was accused of having sex with 6 different juveniles. He was charged with 6 counts of sexual battery on a juvenile and intimidating witnesses. He was given 8 years and 5 years. This involved 6 different juveniles. In 1988, he pled guilty to the attempted manslaughter, which was reduced from attempted murder. He shot a man while the man was sitting in his car. I have reviewed the medical records. I've reviewed a video with Dr. Jonathan Roundtree, where he has indicated that Mr. LaPointe has induced squamous cell.
Yeah. So, yep. I mean, you heard that right? 1992, a 14-year-old. 1988, 5 years for attempting manslaughter. 5 years? What? What? And then 95, 6 juveniles, 6 victims, 6. And he gets 8 years. Are you kidding me? And then he has a jury trial from doing this to his stepdaughter from the age of 5 years for years and years and years and years and years. And he's found guilty in a jury and they give him 12. It's like, what is wrong with the system? This stuff is, and in this case, it's like, well, the system won't do it right. Let's have some higher powers inflict some proper justice, in my opinion. Sickening. So people are sick. The jury found them guilty. The judge said, what's the big deal? Just, you're only like an habitual offender. You've only tried to kill someone. You only have molested, that we know of, at least 7 children that we know of. The system is so broken. Here's the court records of one of his things. I just can't with this stuff anymore. It's maddening. It's so maddening. How does someone what judge thinks that's justice? What judge would not have thrown the full book at him? You can't make it up. So defendants, Bill and affirmed one count of aggravated incest. A jury found him guilty in response to verdict, attempted inducement of a juvenile. The jury found him guilty to be the victim to be under the age of 13 at the time. He was sentenced to the maximum of 12 and a half years. Oh, it was the maximum. So the jury found him guilty of attempted, not of actually doing it. So it was attempted. For some reason, they didn't find him guilty of doing it. They found that she was under the age of 13, and the judge gave the maximum. So this is the legislator's fault. That the maximum that you can get for attempted molestation of a juvenile. It doesn't make any sense. This is like another way of how did the jury find him? He's charged with one count of aggravated incest. And a jury found him guilty of the responsive verdict of attempted indecent behavior of the juvenile and not aggravated. So the judge gave the full sentence. So this is I guess, messed up jury, trying to oh, well, let's just find him guilty of one thing. And the legislator only giving a maximum sentence of 12 and a half years. Wow. It doesn't make any sense. It's just. Wow. So here are the facts. In 2004, Ashley had 3 children with a prior relationship, 1 boy, 2 girls, including ER. The family moved from Church Point, Louisiana, in 2007, where Ashley frequently worked long hours, and LaPointe stayed at home with the children. Ashley testified that on September 2nd, 2011, called tell her that Megan Dupree, ER's friend, has something to tell her. According to the testimony provided by Ashley and ER, Megan told Ashley that LaPointe had been messing with ER. Ashley confronted LaPointe, who claimed to be innocent, and encouraged her not to contact the police. Ashley and her children thereafter left home. Ashley took ER to the office, community services, to report the accusation. A doctor appointment was scheduled, could be examined, and Ashley contacted the church police department. LaPointe was later arrested. ER accused her stepfather of committing countless sexual acts against her, including vaginal penetration and oral sex, from the time she was 9 years old until the time she was 13 years old. 4 years of complete sexual assault of a child, and the jury found guilty. The jury only found guilty of attempted. What a travesty! What a injustice! The family does everything right to put him, and they go to a jury trial, and that's what they find him guilty of: attempted, one count. Is the DA incompetent? Because there are things that are broken, but can you imagine being a jurist and say, you know what? I think that there was only one attempt. It never actually happened. I don't believe any of the accusations. It was just one attempt and it never happened. Okay. Sufficiency of evidence. So here was the evidence introduced at the trial. One, any lewd, lascivious act upon a person in the presence of a child, and a transmission, delivery of utterance of any textual, visual, written, or communicating reasonable belief under the age of 17. Okay. Any person who's having specific intent to commit a crime does, in fact, the purpose of intending directly. Let me see what. A victim or witness testimony alone is usually sufficient evidence in the verdicts, which would not second guess the credibility of determinations of the fact under beyond constitutional standard. ER was born in 98, was 17 years old at the time of the trial. ER testified. So she gets up. The survivor gets up, does the thing that the DA say they never want to do. They never want to get up and go to trial. She gets up and she testifies in front of that jury. And she says there were countless times in which LaPointe would force her to engage in oral sex, fondling, and sexual intercourse. She testified that the sexual assault began when she was 9 years old and continued until she was 13 years old. That's 4 years of brutal assault on his stepdaughter. ER further explained that the jury that she did not initially tell her mom about the sexual assault because she was afraid of LaPointe. She described her home life as violent and testified that LaPointe was abusive towards her mother and told her and her siblings, recounting instances in which LaPointe would slam her into walls, whip her, and leave bruises on her body. LaPointe ER fearfully by telling her that he had shot people in the past, which is true, and gotten away with it, which is true. And I wonder with the mentioning of this in her testimony, if they would have been able to bring that up, the fact that he had shot someone in the past. I wonder if the judge would have allowed that more than just speculation, but it's fact. But anyways, ER stated that ultimately the confidant in Megan debris about the ongoing sexual assault and that Megan was first informed by ER's mother of the abuse. ER denied being coerced by her mother and denied that she was lying. In her testimony, Ashley affirmed that Megan that informed LaPointe's sexual abuse. She testified that although LaPointe denied the accusation, ER insisted that it was true. Ashley then removed her children from the home and reported the abuse to proper authorities. Dr. Scott, an expert in forensic examination of child abuse, reported to testify during the examination, reported history, repeat sexual abuse. She reported that sexually abused approximately 5 times a month. 5 times a month. And the jury says 1 count of attempted. How is that possible? Dr. Bergster further testified that only hymenal remnants remained in ER's area, indicating repeated episodes of penetration, although he did not find any tears, bruising, lacerations, right? The last sexually abused 3 to 4 months prior to the examination. When asked if they could draw any conclusion, a reasonable degree of medical certainty, whether ER had been the victim of repeat sexual abuse, particularly penetration, Dr. Burke said confirmed that he could. He testified that due to the medical finding, there was sexual abuse to some degree, although he cannot identify the abuser. Although ER testified that she was once sexually assaulted by Frill Solo in 2007, Dr. Bergsart determined that the damage by her hymen was inconsistent with a single sexual assault. The hymenal remnants not indicated repeated episodes of penetration, but indicated that someone other than Frill had sexually assaulted ER as well. This poor girl. Admission of other crimes. LaPointe next argues the trial was erroneously admitted prejudicial other crimes of 1995 sexual battery. So I was wondering if they would have admitted that. And the trial court ruling on admissibility of the evidence reviewed his prior charges, right? Did they allow that? Here, only in similarity to 1995 convictions and the presence of others offenses, both constitutional sex offenses admitted against juveniles under the age of 15, although the evidence presented suggests he was able to exercise control over ER and the familial relationship. There's no evidence of his relationship with the victims in 95 convictions. Thus, we determined that past and current offenses are similar only to the extent that they demonstrated his propensity towards juveniles under the age of 15 and are not prejudicial as to warrant exclusion. Any inculpatory evidence is prejudicial to a defendant, especially when it's probative to a high degree, used as a balance of prejudicial limits. I'm trying to figure out, did they allow it or did they not? Because there was similarity in the 1995 convictions and the present offenses charge, it's because the evidence presented at the jury's verdict indicated the jury did not determine guilt based on a granted difference from the proof of specific charge of prejudicial 95, Moreover, because the determined witness testimony alone was sufficient for a jury found guilty of indecent behavior with a juvenile, and because the jury returned a verdict of lesser responsive verdict. The jury returned a lesser responsive verdict. Shame on the jury. You know, and I guess this whole thing is I think that this unattributable to the admission of LaPointe's prior convictions, even if they have been according to we affirm with the defendant conviction for attempted indecent behavior with juvenile, we order the trial court to properly inform defendant of prescriptive period of filing post-conviction relief within 10 days. Addition. I don't understand. I guess they said that it was okay that they brought it up and they affirmed the conviction. But what I am infuriated about, I really am, and what I just want to get some clarification on is what were the charges? The charges, and there were lesser charges. So they only charged him with one count of aggravated incest, and a jury found guilty of a responsive verdict of just attempted indecent behavior with juvenile. That was it. How is that possible? First of all, why did the DA not come in with as many charges as you could, with all the counts that you would throw on this case? Aggravated sexual assault, aggravated incest, a crime against nature. I mean, do every single charge that you are allowed to do. They gave the jury, it seems, 2 options. And the jury, for some reason, looked at her, the survivor, standing up for herself all these years later, and they said, attempted indeed. What do you think that meant to her? What is wrong with this? What is wrong with the people? You can't make this stuff up. What can get you more angry? An incompetent DA that they would bring just one charge? Here you have the victim getting on the stand, having to go through that trauma to then have a jury essentially say, "You're lying. I don't trust you." And get a slap on the wrist sentence. It's sick. It's sick. It's sick. Imagine if he wasn't sick in bed. He would have gotten out, you know? He's a young guy. Unbelievable. He literally got away until karma took over. I mean, he was born in 63. He would have had a lot of life left to wreak terror. But this is a perfect example of how a system is rot. Rot. That he had all those previous convictions, and yet they could have even gotten him with an habitual charge or something. Nothing. They failed. Everyone failed this girl. But with that, I'll let you go.
Knows is a first felony offender with the parole eligibility date of April the 22nd of 2020. He's not eligible for good time. He has a full term date of April the 22nd of 2023. He's currently serving a 5-year sentence on the charge of indecent behavior with a juvenile, having been sentenced on May the 9th of 2018. Mr. Munoz, your case has been assigned to Mr. Pete Freeman. I'm going to ask you to please answer any questions he might have, and then we'll.
Okay, Mr. Munoz, how old are you?
42 years old.
Okay, and how long have you been in prison?
4 years and 3 months.
Okay, what's your educational level?
What do you mean by education?
How much school have you taken?
I just done GED while here in prison.
Good, that's a good thing. Your original charge was aggravated rape, and it was played down to indecent behavior with a juvenile. Tell me what went on. What happened?
They said a lot of stuff went on. First, the grandma of my stepdaughter called the child services, and then the child services went and talked to me, and they said it was fine. I cannot spank my stepdaughter, and after that, I started a fight with my stepdaughter grandma, because my stepdaughter got hurt on her house, and then I called child services on her, so I started like a fight. And then after that, they called her grandma, called a school saying that I was abusing her, my stepdaughter. So when they talked to her, everything was fine. It's just they said that they saw me having a relationship with my wife in my room. So that's why they gave me indecent behavior.
Okay, let me ask you this. Did you ever molest your stepdaughter?
No, sir.
Why would your wife say that you admitted to her that you molested her stepdaughter?
She was mad at me.
You still mad at you?
Yes. I guess I haven't talked to her in 2 years, or a little more than 2 years.
That concerns me. I mean, the little girl described what was going on. I mean, you admitted to the wife, but now you're saying that you didn't do anything, correct?
Yes, sir.
Okay. I see you took your sex offender classes. You took a victim awareness class. Is that correct?
Correct.
What did you learn in that victim awareness class?
I learned about the consequences of your actions. I learned like also drug abuse. I used to drink a lot, alcohol. I never used drugs, but alcohol is considered another drug. So yes, I used to drink a lot. I was drinking while I was working and after work, and I understand I couldn't act like make right decisions at that point. While I'm here in prison, I understand that that was wrong, and also I was fighting a lot with my wife, so I didn't get the help that I needed on that time, so I can take the right decisions. And
Did you attend any AA and A meetings while you've been incarcerated?
AA now.
Do they have AA there?
Do they have?
I mean, I think we just heard they had it there. Did they have AA there while he's been incarcerated?
How long have you been at this facility, Mr. Munoz?
A year.
No, sir. We haven't had it since 2020.
Okay.
Yeah.
Where were you prior to coming to this facility? What facility you at? What prison were you in before coming here?
Tanyu Bahoa, Amy.
Okay. What is your transition plan? I mean, what are you going to do if you got out?
Well, just work, try to get a degree. When I was in Mexico, I didn't get a chance to go to school. I just went to school just to learn how to read and write, how to learn English. I learned English here while I'm in prison. I learned more how act with another person, how communicate with another person, and acting my behavior with others. And so I've been learning a lot, and I still want to learn more. When I get out, I'm gonna get some degree.
Where you
College.
going to work at?
I work in construction, and I did a lot of stuff, different things, so I can work on anything.
Where are you going to live at?
I got a cousin. He offered me his house. I got an address, but still, if that doesn't work, I got more family. I can call and ask for help.
Where's this house located?
In Louisiana.
You have victim opposition. You also have law enforcement opposition. That's all the questions I have.
Sir, you said that you and your wife was fighting a lot because she indicated in her record that you were a good provider. I mean, you paid the bills and you did what you should. So what was y'all fighting so much about?
Well, she started listening to some of her friends that I was Mexican and I was too macho, and I wanted to do like everything I said, and it wasn't like that. I always tried to do the best for both of us, but she got two friends telling her like, "Oh, you are American citizen, you can do whatever you want. You don't have to listen to no man." And me, I was mad, and I started drinking for that reason. And used to punish her and punish me at the same time. I started drinking a lot, So that's why
Okay.
we was the argument all the time. It was no fights, no like physical fights, but arguing all the time.
Yeah,
And
she said, provider, you brought the money home, you paid the bills, you were a good
Yeah.
provider.
yes, I was supervisor in my job, foreman. I was a
Okay.
leader, and I would also translate a little bit for my coworkers. So I help a lot of people too. But
Yeah.
the relationship between my wife, ex-wife, and me was way before that because I was married when I met my wife, and then I got divorced. But I still was seeing my ex-wife when I was with my wife, and so she never does. And also, she told me she never forgot that, so that's why she was mad all the time with me.
Okay, so, just imagine this for a minute. You said you were drinking while you were at work. You were drinking when you got off work. Is it possible you could have done something and just don't remember with the 9-year-old?
It could, yeah, because I was drinking a lot.
Yeah.
Yeah,
And I just, again, I want to commend you on the high set. I saw that November the 12th of 21, you got your high set. I just want to commend you on that. Job well done.
thank you.
That's all right.
Mr. Munoz, I have a question. You pled guilty to indecent behavior of the union, right?
Yes, sir.
Why did you plead guilty?
My wife told me we're gonna get divorced. I was depressed, and I didn't care at that time my life no more. I said, well, you're not gonna be with my.
Aggravated rape was sentenced substantially higher than the 5 years. They offered you a deal a year before you actually pled. What was that deal they offered? How many years did they offer you before?
25.
And they came down to 5, is that right?
Yes, sir. Because it was indecent behavior.
Mhm.
Thank you. That's all the question.
And the staff have anything to share with us about? Staff?
Just to recap what y'all have already said, generally, offender Munoz graduated in February of 2022. As part of his treatment at the sex offender unit, he has also completed 3 months of Steve Hoyle, which is kind of our standard substance abuse treatment for anybody who comes through. And as part of his sex offender treatment, he did take anger management. That's not going to be reflected on his credit sheet because it's included in the sex offender credits, but that was included as well due to some of the domestic issues.
Has he completed all 4 phases or just phase 1 and 2?
All 4 phases, yes, ma'am.
Oh, okay. All right, thank you. Let me see that. Thank you.
Mr. Munoz, is there anything you'd like to say before the panel votes?
I just like to say that I regret my wrongdoing, my actions, and even if you don't grab me, bro, I thank you for your time. And even if when I get out, I'm gonna try to better myself, to get a degree, to be a better person. Not only for me, it's just because around people around me. I want to think about whoever's around me to be safe.
Thank you very much, sir. Mr. Freeman, go ahead, vote.
Yes, sir. Mr. Munoz, you kind of totally denied any sexual conduct with your stepdaughter. I think there's a lot more to it than you would really say, or you probably wouldn't have took the plea. You already got a big reduction from the original charge. So my vote is to deny due to the seriousness of the incident.
Sir, again, I just want to commend you on what you spent this time well. But the proximity of good time day, you're getting out in April of 23, and the impact of the crime on the victim, my vote is to deny as well.
You have 2 votes to deny, Mr. Munoz, based upon all of the things my colleague said, but primarily the fact that You have a full term date of April the 22nd, 2023. My vote is likewise to deny. So good luck to you.
Thank you.
We will close out at Webster. Thank you very much for all of your help, staff there.
Yes, sir. Mr. Marabella, thank you, sir.
Thank you.
Yeah, so I think I picked up a few pretty obvious lies in this case. He comes in with the defense of, I didn't do it. It's that the grandmother called child services on me because I was hitting, my stepchild. So then I wanted to get revenge, and I called child services on her. And then at that point, she came in and saw me and her mother doing something, and that's why. Um, And then they offered me a plea deal of 25 years, turned it down, waited a year for trial, ended up taking a 5-year deal. And one just has got to say, how does that happen? How does it go from a 25-year plea deal to then just 5 years? It's the system for you. Now, there's no information on him. Richard couldn't find anything in the initial notes. I ran one more search before doing this just to double check. It's quite great. It must be a popular name because a lot of names did pop up for Munez and for Grotto, for the full name, in similar offenses, but not the same person. So I don't know where he is. You would think he'd be on the registry or something. But so some of the lies that I think I picked up on, one is that he claimed that he had learned English while in prison. But then a few sentences later, he claims that he was the foreman for his job and the translator before he was sent to prison. So which one is it? It's just some people who are professional liars that can't keep track of their own lies. Now, it could be his English became an expert at English in prison. But anyways, I thought I picked that one up. The other thing that if there's any doubt at all, which over time I begin to when I first started doing these hearings, I would say, okay, it's a possibility that you would get screwed, that you would get sent to prison and just take a 5-year plea deal if you felt like the cards are stacked against you or whatever. But as I watch this stuff, I don't believe these people hurt children at all. At all. I just don't. I've been fooled a few times actually, but so now I'm at the point where I simply don't believe it. And who was it Miss Wise that said, well, or is it, okay, well, is it because you were drinking? Is it possible that maybe you didn't remember? And he's like, yeah, that's possible. And for me, there it is. Like, if you're innocent and you didn't sexually assault, you're not going to say, yeah, it's possible I drank, so maybe I did it. You'd be like, no, there's definitely not something I did. And he didn't say that. It's very clear that he did it. The DA is weak, and they gave him a 5-year plea deal, which is an insult to the system, an insult because of what he will do when he gets out to future children. And it's disturbing. It really is. But, the DA's hands were tied. We think they were tied. We don't really know. Was it that the victims wanted to get up and speak? Survivors wanted to speak, or did they just not? And did they feel that they had nothing to take him to trial with? And he played hardball. He waited a full year before trial, didn't take the 25-year deal. But that's it with this one, and I don't really have anything else to add on it. It is scary though. And with that, we can move to the next.